Hi, my name is Kristen Weeder, and for my second con law video, I decided to analyze the case Barnes versus Glentheater, Inc. In this case, the plurality held that the enforcement of a public indecency statute to require nude dancers to wear pasties and a G-string did not violate the First Amendment, and in this case, I agreed with the plurality. In analyzing the present case, the plurality agreed that erotic dancing was expressive conduct, although only marginally so. They said that it was within the outer bounds of it. I had trouble seeing why nude dancing was expressive at first, but upon reading the opinion, I agreed that excessive dancing could be trying to convey some sort of erotic message or sexuality of the dancers. To analyze whether the Indiana statute was valid, the plurality used the O'Brien test, which has 4 factors which I'll address in turn. The first factor is that the government regulation must be within the constitutional power of the government, and I think that's satisfied. I agreed with the plurality on that. To aid in their decision, the plurality looked to the history of public indecency statutes in the state and throughout the nation. And in the state, the public indecency had been a criminal offense at common law, and also there were several statutes in the past that had regulated public indecency. Across the nation, there were 47 states that had banned public indecency. So using these examples, they showed that the government regulation was within the constitutional power because they had regulated it before. I also agreed with the second factor that the government regulation must further an important or substantial interest. The plurality uses the same examples as before, that there had been public indecency statutes in the past in the state and across the nation to show that it had been an important or substantial interest before and that they had no problems with that before, expressing that before. So they were trying to further that reason yet again. And I agreed with the plurality on that as well. Justice Souter in the concurrence makes an argument that the state has an interest in combating the secondary effects of adult entertainment establishments, and examples of those effects would be prostitution, sexual assault, and other criminal activity which may come with the adult entertainment world. And I don't necessarily agree that this is as strong as an argument as the public indecency. I think that the state's interest in regulating the morality of the area is more important than the secondary effects because they did not provide any information on the secondary effects and what they were and how they had affected the area in the past. The third factor I think was also met, and the third factor is that the government regulation must be unrelated to the suppression of free expression. The plurality said that the regulation is in place for public nudity and not for the erotic dancing. In this case, the erotic dancing is the expressive conduct, and they're not. It's unrelated to the regulation. So I think that the third factor is met, and that the expression is not being regulated. It's the public indecency. The nude dancers say that the state is trying to prevent the erotic message of their dancing, and I disagreed with this. In the case, several of the nude dancers had expressed that the reason that they wanted to be totally nude as opposed to wearing pasties and a G-string was because they thought they would make more money that way. Therefore, I think that the expressive conduct wasn't what their interest was. I think that the expressive conduct was secondary to the money that they thought they would make if they were completely nude. So I did not agree with the dancers' argument that the state was trying to prevent the message of their dancing. The dissent argues that because the state is allowing the dancers to wear pasties and a G-string while dancing but not to dance nude, that they must be regulating the erotic message of the dancing because there's so little difference between being nude and wearing the G-string and pasties. And I thought that this was a valid argument, but I also think in the context of nude dancing that the sole purpose of it is being completely nude. And in the fourth factor, they have to limit that as much as possible. So I think in the context of this case that the dissent's argument wasn't as strong as the plurality's. The fourth requirement was that the government regulation must be no greater than essential to the furtherance of their interest, and the interest again was the public nudity. So the plurality says that the addition of pasties and a G-string is the bare minimum that they can add to regulate the public nudity, and I agreed with that. It's not as though they're asking dancers to be fully clothed or to even wear full underwear. They're asking them to wear, minimal stuff just to cover the essential areas, and I think that that's no further than essential to further the interest in banning or regulating public nudity. So in conclusion, I agreed with the plurality that because each of the O'Brien factors was met, and because the O'Brien factors are a test to determine whether expressive conduct is within the First Amendment, I agreed that the Indiana statute was valid and was constitutional. Thank you.